I'd like to devote this show to the question of what rules. The legislature has been fond of passing changes to the Condominium Act. When I first started practicing in 1982, the Condo Act was probably, let's just say, for example, 10 pages long, and there were few, if any, rules by the DBPR, the Bureau of Condominiums, etc., Division of Land Sales. So what's happened since then is that there's been a literal explosion of state regulation of condominiums and condo associations. There was no, in 1982, there was no regulation at all of homeowner associations. That law has just come into being, and that's been amended a number of times. In fact, I have a Chamber of Commerce speech I give saying that the operation of condo associations is probably the fourth most highly regulated entity in Florida, after maybe nuclear power, parimutuel wagering, and funeral homes, or something like that. And it's really difficult to be a condominium association volunteer director. All of you who are directors are cheap at twice your pay. And I know what you're thinking because I know what your pay is, all the aggravation you can stand. But basically, questions often come up, for example, what governs? Does a change in the Condominium Act govern, or do our documents govern? And unfortunately, the answer is it depends. Let me give you an example. The vast majority of associations have bylaws that say that a quorum is a majority of the voting interests. Well, a few years ago, the Corporate Act was changed to say that the quorum is a maximum of 30%. So then the question becomes, okay, well, what is a quorum? Now, in condo associations, because of the way the elections are now handled, elections have turned into kind of somewhat dry and clinical matters, and I think only 20% of the voting interests have to cast ballots. But then the question becomes, for example, when you amend the documents. Let's say your documents say that the declaration can be amended at any meeting at which a quorum is present by a majority of the votes present in person or by proxy. Okay, well, let's do the math. If you have a 100-unit condominium with 100 voting interests and you need a majority to have a quorum, that's 51 votes. And you need 26 of those votes if the majority controls. If the Corporate Act controls, then you only need 30 people, 30 voting interests present in person or by proxy, and you would only need 16 of those. So the question is, what happens if you get less than 51 participating and more than 30? Is it a valid amendment? And the answer is there's no case law on it. The reason why there's a question on that issue, for example, and on a lot of these issues, is that the Florida Constitution says that there shall be no law which retroactively impairs the obligations of a contract. And that has been used, for example, in the HOA setting to throw out the 1 year or 1% recovery by foreclosing lenders who take title. And that was the Coral Lakes Busey Bank decision of about a year ago. Well, it was February 2010, which held that mortgages which were recorded before the law changed on July 1st, 2008 are not affected by that law, and they are entitled to rely on the language of the documents. Now, I think that decision happens to be wrong, but nonetheless, the judges disagree with me, and they're judges and I'm not, so it doesn't really matter what I think. But the bottom line is, any mortgage recorded before July 1st, 2008 and foreclosed results in the holder of the mortgage not being responsible for any assessments. So there you have it. The Supreme Court has also broken the analysis down into whether a change in the law impairs a contractual obligation as to whether it's substantive or procedural. For example, in the old days, prior to mandatory non-binding arbitration, condominium associations, in the vast majority of documents, said that the association could go to court to enforce the restrictions. Well, the Supreme Court would probably interpret, and this has never been taken to the Supreme Court, but you've got arbitration in condos and you've got mediation in HOAs. I think that every lawyer that I know, including me, would say that all the law does is change the procedure by which the remedies are undertaken and not the substantive effect of the remedy. And that's why it's called mandatory non-binding arbitration also, because associations are mandated to go to arbitration before filing suit, but it's non-binding because the Florida Constitution also says that every Floridian has the right of access to the courts. And case law involving medical malpractice arbitrations being binding was found to be unconstitutional. So every issue kind of stands by itself, and you can't always have a black and white or even gray and dark gray decision. You got to look at every issue, unfortunately, and that is, at its heart, that's legal analysis. And while some things are pretty straightforward, others are not. Generally speaking, as a broad general rule, whichever provides the most protection to someone is going to govern. For example, my example about the minimum quorum requirement. I think it's more protective of people's rights to require the higher quorum than the statutory lower quorum, especially if you're going to change a use right in the declaration. But that's just my opinion. So good luck with it. Hopefully you have sharp managers. If you're self-managed, I hope you're well educated, and I hope you have good lawyers who are willing to answer a freebie now and then, as I always am. If you call with a generic question or email, I'll answer it, and I think every lawyer that I know would just about be willing to do that. If it gets involved and detailed, the meter's probably going to run, but that's an individual decision. So good luck with your interpretations. There's a lot of resources out there, and till next time, we'll see ya.